Hey everyone, welcome to the final installment of the criminal trial process. We'll be looking at the role of juries, including verdicts. Now, juries are only involved in district or supreme courts in the adversary system and will consist of 12 people whose job is to find fact. Now, the role of the jury is more like a tribunal of facts, and the jury doesn't play a role in determining the sentence. It's purely just to find the truth. In a trial by jury, the case is heard by a judge and also with the jury. The court proceeding is the same as that in a summary hearing, except that the jury, not the judge, decides the guilt or innocence of the defendant. The way in which juries are selected and operate is governed by the Jury Act of 1977 of New South Wales. Some facts about juries are that in criminal cases there are usually 12 people who form a jury. However, under amendments made to the Jury Act in 2006, the court can impanel up to 15 jurors for lengthy criminal proceedings, though only 12 of them will ultimately determine the verdict. Jurors are selected from electoral rolls. So if you can vote, you can be in a jury. Jury service is compulsory unless you are exempt, in which we might go through those a bit later. Both the prosecution and defense may reject possible jurors if they feel they'll be biased against or in favor of the accused. And lastly, the verdict of the jury can be a majority verdict of 11-1 in New South Wales criminal trials. Under amendments made to the Jury Act again in 2006, a majority verdict will only be accepted by the court if the jury has deliberated for at least 8 hours and the court is satisfied after examination on oath of one or more of the jurors that it is unlikely that the jurors will reach a unanimous verdict after further deliberation. So, in terms of eligibility, you just need to be an Australian citizen over 18 years of age, which is the same as if you're able to vote. Ineligibility includes people employed or engaged, except on a casual or voluntary basis, in the public sector of law enforcement, criminal investigation, or the provision of legal services. People who are unable to read or understand English, and that's for pretty obvious reasons, and people who are unable because of sickness, infirmity, or disability to discharge the duties of a juror. So that could be mental illness, that would be, or something similar to that. People that can be excused from serving on a jury are practicing dentists, pharmacists, and medical practitioners. Carers of children and carers of the ill or disabled people. So if you're a full-time carer or close to it, you are exempt. People who live further than 65 kilometres from a courthouse. And you may also have a good reason of a temporary absence from your home, like a pre-booked holiday commitment, though that really only will work once. You might yourself have a sickness or disability, or you might have exam or study commitments. So jurors are randomly selected from the electoral roll. The process of selecting a jury is known as impaneling, which I mentioned earlier, and the prosecution and defense may challenge a particular juror's selection. Now, the jury will decide the guilty or not guilty aspect. If a verdict cannot be reached, it's known as a hung jury, and it actually can lead to a retrial. Prior to 2006, where we had that law reform, a jury's decision had to be unanimous. Now we know that majority verdicts of 11-1 are allowed after a reasonable time, that is 8 hours, and also that the court is satisfied that the jury is unlikely to reach a unanimous verdict. Retrials, and this is important, are a major strain on both the prosecution and the accused, as well as the criminal justice system. Now, there are always pros and cons of this sort of stuff. So for a majority verdict, removing unreasonable jurors, because if you've got one very obstinate, very stubborn juror, you will not be able to proceed and get a unanimous verdict. and they could have their own personal reasons for that. It avoids time delay and cost, which again, we already know the criminal justice system is very tied up and very slow, so any improvements are welcome. And saving the victim from a retrial, because as we've just mentioned, it can be very confronting for the victim to have to go through this, particularly depending on what type of victim they are. So, against a majority verdict. So, disagreements are rare, so why make allowances for people to make disagreements? It discounts the possibility of finding a reasonable doubt decision and may persuade the jury from beginning that they only need to get 11 on account. So it's about expectation management. If you're only trying to get to 11, sometimes that's all you'll aim for, as opposed to trying to get all 12 and be a unanimous decision. This is also really important for balancing of rights versus the individual versus society and the community. So this really addresses your themes and challenges. So now we just have some review questions, guys, for the entire criminal trial process, and I want you to have a think about how you can answer each one of these. Now, unfortunately, my formatting has gone out, so these are the different questions. So list the different courts, clarify the differences between the adversary and inquisitorial, summarize the role of the police, magistrates, etc., explain the role and purpose of legal representation, examine defences, including partial, discuss the relationship between burden and standard of proof, evaluate the advantages and disadvantages of the jury system, and discuss whether the criminal trial process is an effective means of achieving justice. Well, that's all we have time for. Thanks very much for watching, guys, and all the best.